and whether or not the victims' families were right to claim that Nottinghamshire police have blood on their hands. Terry in Southgate.
Oh, hi, Sangita. Great show. My view is, and again, my heart goes out to the families. I can't imagine what they've gone through and what they're going through now with this verdict. I don't think it's the police's fault. I think it's the CPS's fault. It's the court's fault. It's the lawyers, the slimy lawyers that find any little way they can to get someone out of, actually going to jail.
Are they slimy lawyers, or are they just doing their job?
No, they're slimy. They're the same lawyers that manage to get these guys that stab people, to do a year in prison, and half of that if they're lucky, if they're good behaviour. They're the kind of lawyers I'm talking about. The whole system's wrong. The whole system's wrong.
Although you do accept hang on a minute, you do accept that the way the criminal justice system works is that there is a prosecution that in this case was brought by the Crown Prosecution Service in the public interest on behalf of all of us, and that the person in the dock does have the right to a legal defence.
They do, but that's not, in this country, how it works is if you've got the money, you'll get off of it. That's the long and short of it.
Well, not in this case, because I'm pretty sure that Calocane would have had, probably, I'm guessing here, his defence funded by the public purse through legal aid.
Exactly, yeah, legal aid. So these legal aid lawyers that didn't cost anything, in this case, obviously, they've managed to get him away with manslaughter. He murdered 2 children and a working man in his 50s, I believe. And he's going to spend, the rest of his life in a very comfortable, medical prison, Dartmoor, I forget the name of it, but, where Bronson was kept for a while, that kind of place, where it's, he'll live his life out comfortably.
He's in a mental institution. That's not comfortably. But listen, Terry, I'm very glad that you raised this point, because one of the people that you claim is a slimy lawyer is on the line next. Terry, stay listening. Joseph Kotrie-Monson is a criminal defence lawyer at Monson Solicitors on Fleet Street who specialises in high-profile criminal cases. I imagine you have something to say about Terry and his views?
Well, I'm sure he wouldn't have been quite so vociferous if he knew that I was speaking next, Sangita. Good afternoon to everybody at home.
Afternoon.
Of course, everybody's entitled not only to their opinion in a free society, but also to a defence if somebody says they didn't do something. As to whether lawyers are slimy or not, I think it depends lawyer to lawyer, just as it depends man on the street to man on the street.
Setting aside Terry's insults, let's get to the substance, I think, of what he was alluding to. We heard the victims' families in this case saying that they were angry that the Crown Prosecution Service had accepted a plea of manslaughter, and they felt that that had come out of nowhere. They said that it was only 4 months ago that they heard that this was ever a possibility, and that until that point they believed that Calocane was going to be tried for murder. Yeah. Can you explain to us what might have happened and how this, I don't know how to describe it, possible miscommunication?
And it's so interesting that, as some of your other comments I've heard, Sangita, on other calls, without trying to flatter you overly, you're right. It smacks of miscommunication. And the reason for that is that this had all the hallmarks from an early stage to anybody looking at it, even from the outside, of somebody who was crazed and suffering with mental illness. That doesn't mean for a minute that the prosecution should have been saying to the family, right, we're going to be accepting manslaughter on this. Generally speaking, in my experience of serious murder cases where there is diminished responsibility, a serious mental condition, the prosecution are loath to accept it unless their own expert has seen the person, unless the court expert often has seen the person. And it's just really obvious, because when they're in doubt, they leave it to the jury. What might be the case here, and I'm loath to comment on a case I wasn't involved in and at the cold face with it, but what might have been appropriate here, and you mentioned miscommunication or a failure to communicate. I think management of information with victims' families is incredibly important if you're a prosecutor. I'm assuming, of course, I defend people, but it looks to me as if it may well be that, in their focus on the murder charge, obvious signs that this may well be a case where, first of all, manslaughter might be appropriate, and secondly, also a hospital order under the Mental Health Act. Now, just because the prosecution agreed manslaughter, and this was agreed without a trial, by consent on both sides, it must have been that obvious. If that's the case, then it doesn't necessarily mean that a hospital order will follow, but the judge's decision not to impose a life sentence of imprisonment, which was another option, and instead, under the Mental Health Act, make that order, I think it shows how very, very ill this man was.
I heard speculation in the week that there may have been an alternative course. And I'm going to ask you to reflect on how much weight you think that carries. And there was a suggestion made by various commentators that perhaps Calocane could have been tried on murder with some kind of acceptance that he was also mentally ill. I mean, was there any prospect of that happening?
It often happens, but that doesn't necessarily mean that will result in the outcome that a family wants. And I make no criticism of a victim's family for wanting the full extent. You know, the reality is, if it happens to one of my family, the criminal justice system is not enough to satisfy the anger that I have, and I'm sympathetic to that. The reality here is that both sides, an experienced King's Counsel for the prosecution will have said internally, if we run a trial on this, then we are putting ourselves in an inevitable position of losing it after the trauma and the kind of morbid excitement and aggravation and, you know, all of the emotions for the family that goes with a trial, as dissatisfying, as short-circuiting that is, resulting in the same outcome. I've heard it said, also in similar comments to the ones that you've read by legal analysts, that it was almost inevitable. Now, of course, one can't, with a crystal ball, predict that. It would result in the same verdict from the jury. But in my experience, the prosecution, even in cases where, as defense lawyers, you can see your client is incredibly ill, the prosecution, only in the rarest of cases, will take the expert's view of it. They will put it for the jury. You know, it's too great a decision to take personally and face criticism, so they put it before the jury. I think the prosecution saw something relatively early here, albeit it appears maybe not communicating that possibility early enough to the family, that this really was inevitable, and it was best to try to do it quicker.
Joseph Kotrie-Monson, a criminal defence lawyer at Monson Solicitors on Fleet Street in London, thank you very much indeed for your professional view.